Reproductive rights and recourse to medical methods to have children are enshrined in Article 5, Paragraph 1 of the Greek Constitution. Everyone has the right, based on the development of one's personality, to have offspring according to one's wishes. One method of medically assisted reproduction is the transfer of fertilized eggs after IVF. The surrogate mother is impregnated and gives birth by the aforementioned method using eggs alien to her. She gestates the embryo on behalf of another woman who wishes to have a child, but is unable to become pregnant for medical reasons. Greek Civil Code regulates issues arising from medically assisted reproduction. Judicial permission is required before transferring the biological mother's fertilized eggs to the body of the surrogate mother. The conditions for the granting of such authorization by the Court of Justice are as follows. The applicant must not be able to become pregnant without medical intervention, be a legal adult, and not have exceeded 50 years of age. The surrogate mother must be an adult and healthy so that she can become pregnant. The applicant and surrogate mother must reside in Greece. Fertilized eggs implanted in the surrogate mother's uterus should not belong to her. These ova may come from either the woman who wishes to have a child or from a third woman as an egg donor. There must be a written agreement between the person seeking to have a child and the surrogate mother, as well as her husband if she is married. Persons seeking to have a child may be either a married couple, a couple living together in a free union, or an unmarried woman. A private document is sufficient for this agreement. The agreement must specify that the legal parents are not paying the surrogate mother to have their baby. However, it is expected that the person seeking to have a child pay for all expenses required for pregnancy, gestation, childbirth, and postpartum recovery. The surrogate mother may also receive payment that compensates for lost wages from work for the duration of the agreement. The Court of Justice determines the amount of procedural expenses and compensation covered. According to Article 1464 of the Greek Civil Code, the mother of the child is presumed to be the woman who was given the relevant permission. In other words, the woman who wishes but is unable to have a child for medical reasons. The child's father is also considered to be the husband of the woman to whom the judicial authorization was granted. The surrogate mother and her husband are not related to the child. Timing is crucial. If the gestation is carried out without the court order granting authorization before the transfer of the fertilized ova, the surrogate mother and her husband are considered to be the child's mother and father, respectively. There is a possibility that the surrogate mother will have regrets and refuse to surrender the child, even though the legal procedure was followed. This is not unlikely if during pregnancy the surrogate mother develops an emotional bond with the child, which she considers her own, even if that is not her biological offspring. If the surrogate mother withholds the child, Civil Code procedure enforces the judgment, and the child is handed over to the woman to whom the judicial authorization was granted. With surrogacy, thousands of couples worldwide can have a child. However, we should be concerned that, despite the rapid development of technology and the improvement in living conditions of recent decades, rates of infertility have increased significantly at global level. Razzo and Associates law firm is constantly dealing with family law cases. We'll be happy to provide you with our services. Thanks for watching.